Well, I think let us get going. First of all, welcome to everybody to our Elder Voice Family Advocates webinar, Fight Back and Protect Seniors. First, let's take care of just some housekeeping issues. This is being recorded and it will be posted on our website for others to view later, so please pass that information on. Also, use the chat feature on the bottom bar of your screen to ask your questions, and then we'll address those at the end of the presentation. So with us today are our guest speakers, Senator Scott Dibble, Representative Ginny Klevorn, and Suzy Scheller. Senator Dibble has been a champion of elder care issues for a long time, and he represents Senate District 61 and was an invaluable supporter in previous elder care legislation. He was first elected to the House of Representatives in 2000 and then the Senate in 2002 and has been re-elected every time since then. Representative Ginny Klevorn is a freshman legislator from Plymouth and House District 44A. She quickly took up the cause to help improve care for elders and supported the 2019 elder care reform legislation. I cannot tell you enough of how skilled and determined both these legislators are. Now, just to give a little history, and Steve, could you put up our timeline graphic? As this graphic shows, there's been a considerable amount of progress since 2017. And then all of this culminated in 2019 with the hard work of a lot of folks. And we did get the passage of the elder care reform legislation, which will go into effect August 1st, 2021. Things were looking pretty good up until the COVID-19 pandemic erupted this year. And we all know how catastrophic this has been for those living in nursing homes and assisted living. 75% of all the COVID deaths in Minnesota are happening at these facilities. And it's for this reason that Senator Dibble and Representative Klevorn are working hard to get the protections passed into law. Before we hear our legislators, I'd like to introduce Suzy Scheller, who will overview the protection concerns. Suzy is the founder of Elder Voice and our legal advisor. As an elder abuse attorney, Suzy's knowledge of elder law has been invaluable in helping us to better understand the impact of the current laws on elder care. Suzy, the floor is yours.
Thank you so much. I appreciate it. I just wanted to briefly review the current legislation, and so I'm sharing a screen here. Hopefully you all can see. The concerns that have come from clients have been wide and varied, and I believe you all have had touches with these concerns as well, whether from a loved one or a family member. But the neglect of care and abuse during the time of COVID has surfaced to Elder Voice family advocates and many in the long-term care community. Concerns of what's happening in the facilities, particularly when visitors aren't able to get in and see what's going on. The restrictions in the independent living environment continue to be a concern, particularly if that independent living environment is in a campus model where there's a nursing home, assisted living, and independent. The lack of physical activity has been a concern. How do we get range of motion exercises and therapies? The termination of services has been a concern in the assisted living environment, which effectively causes a person to need to find a different location during the pandemic. That's especially troublesome. The staff support, we're hearing staff stretch very, very thin, and that is very concerning for providers and family members. The ability to provide the cares, to facilitate communication, to meet the demands on their time given the pandemic. Social isolation is a huge concern. those not being able to be visited by loved ones, the effect on their psyche. We did hear about doctors reporting on death certificates that social isolation was a factor in the deaths of individuals during COVID. And the wide variety of the interpretation of the current CMS, Centers for Medicare and Medicaid Services guidelines, as well as the Minnesota Department of Health guidelines. The wide variety of that interpretation is concerning, with some individuals being able to do window visits or patio visits when outdoor visitation came, and others not. And so these concerns have kind of funneled to the legislature in terms of visitation, in terms of adequate PPE, personal protective equipment, gloves, masks, gowns, staffing, testing, infection control. And as Kris said, hovering around 74 to 75% of the deaths are in long-term care facilities. They're residents of long-term care from the MDH situation room. So what do we do with all of that? We're all adjusting in this time period, but we want to protect those who are most vulnerable. We know where that battleground is. We know based on the death rate, we know based on the vulnerabilities and the reports that our long-term care residents and clients are at risk, at a higher risk. So in steps Senator Dibble and Representative Klevorn introducing a bill, and we want to provide information on that bill. It has been introduced in the first, second, and third special session. The caveat to what I'm going to talk about as the key components of the bill are that discussions are ongoing, including as to specific language. And generally, the COVID protections we're talking about, there's some that are very specific to COVID and some that are more general, are intended to be limited in duration for the pandemic timeframe, and we don't know exactly when that would be, so an estimate may be 2 years. So let's get into some of the content, and I'm going to skip over the overview, just right to some of the key provisions. Electronic monitoring. This was a hard-fought right for residents and families to be able to place a camera in the room of their loved one. When COVID hit, that became a challenge. And so one of the requirements was that the resident's representative needed to attach a written opinion by a provider that the resident lacked the ability to understand camera placement. This was an interpretation by the Minnesota Department of Health on what was needed for the resident's representative to be able to gain authority to place the camera. In this instance, the whole discussion of the camera was really on point to our most vulnerable, who could not articulate harm if it would happen. And so there was a lot of concern related to additional barriers for placement of the camera by this provision, and also a concern of HIPAA, because the notification of the camera is not in the medical record, and the ability to, the need to attach a medical record just to place the camera was a concern. So part of the bill is discontinuing that particular requirement. We believe we have a sufficient alternative to be able to state that the record itself, pointing to the record and not attaching the record, would be sufficient to talk about, to identify the lack of understanding camera placement. Also, without visitors being able to enter facilities, we are advocating for simple devices to be able to be placed by staff with instructions, without liability for malfunction of the particular device, but some ability to allow staff to place simple devices. So we're looking at electronic monitoring as part of a protection, particularly during COVID. Retaliation. Part of the bill clarifies that, because there were some new retaliation provisions that were part of the reform legislation in 2019. They took effect August 1st. But we want to clarify that the retaliation provisions do not affect other rights and remedies that may be available under law. So we have good prohibitions against retaliation, but we don't have what we call that private right of action to enforce those prohibitions. But there are some limited means by which enforcement of retaliation could occur. And we want to make clear that we're not trying to restrict or limit other rights and remedies available under law, particularly under the Vulnerable Adult Act. There is a retaliation provision for reporting maltreatment. So we're clarifying some of that. One main section of the bill proposes provider COVID-19 plans. Those plans would be for boarding care homes, nursing homes, housing with services currently operating under assisted living title protection, and memory care units operating under 325F. Under the housing with services umbrella, we're cognizant to create some duty on the landlord to work with that home care provider who comes in on these plans, because after all, there's some site management that is implicated in the COVID-19 plans. These plans should be made available to residents, visitors, staff, others. They should follow current guidelines. They should include at minimum some testing, adequate PPE guidance, the guidelines for reopening and visitation, including essential caregivers. We want to see a balancing of the rights. The bill addresses some balancing of rights between clients with the risks of COVID exposure. We recognize the rights of clients are being violated, and we're tolerating that based on what we know of the risk of exposure, but we're trying to adequately balance that. To address the protocols in these plans for prevention, as well as responses if positive tests occur, to disclose policies and have more discussion around end-of-life treatment, including hospice, what to expect if you have COVID and you elect hospice, and then honoring existing contracts with those in the independent living models, independent living settings. Again, we're hearing a lot from the restrictions on the independent living settings in the campus model. Other provider provisions, adequate staffing levels, accurate reporting to MDH of COVID cases and deaths, reporting to MDH on the implementation of these various guidelines, again, because we're seeing the varied implementations across different providers, and some enforcement mechanisms by the Minnesota Department of Health. Also in the bill, it is addressing some MDH responses, the request to consult with practitioners, possibly a task force. That was where the concept came from, is those who are directors of nursing, who are geriatric physicians, who are primary care physicians, who are LPNs, who are CNAs. Let's talk with practitioners about how to play out and roll out infection control. Informing the public of the protocols that shape those guidelines that MDH is providing, and to develop a prioritization at MDH for ongoing surveys, not just infection control, and maltreatment investigations. One part of the bill talks about separating COVID positive residents, also sometimes termed cohorting. Generally, the bill is asking for separation of positive residents from those who are not positive COVID clients. And that may be a separate building, it may be a separate wing, or area. Mitigating some of that transfer trauma, notifying agents and family members of any such transfers for the purposes of separation, and ensuring that MA, the medical assistance, still funds those alternate locations, which are separation based on the need for mitigating and limiting spread of COVID. There's a large section and discussion around preventing the termination of services and discharges during COVID. Many of you are aware that the governor issued an executive order preventing evictions generally during COVID. This would be an extension of that to prevent the termination of services in the assisted living or memory care settings during the time of COVID, because the transfers may increase risk of spread of COVID. And also extending the concept of this no eviction order to preventing discharge and transfer from boarding care, nursing home, and long-term acute care hospitals, with exceptions. On a larger scale, there is some discussion about whether the assisted living license start date would be delayed further from 8/1/2021, which was what it is currently. As a part of those discussions, the assisted living license bill from 2019 had many discharge and termination protections. We would like to see those happen sooner than later, particularly if there is a delay. And that includes limiting the reasons for discharge under the new assisted living license, and then before assisted living license, if we do have delay. An appeals process with the administrative law judge at the state of Minnesota if there is a discharge, and a coordination of that transfer. So we're looking at some important protections, discharge and termination protections. There is some infection control language we want to make sure carried over from home care to assisted living license. And again, the concept of including the housing with services provider, the landlord, in some of these discussions, because they have the the management over the site. And then in the bill, there's addressing PPE and testing. We are trying to ensure adequate PPE for providers and testing, and we're working with MDH to identify sources, or the senator and representative, many are working to try to identify funding sources for PPE and testing, but that is currently a part of the bill. And that is a really brief overview, but I wanted to give you an idea of what the concerns are and what the legislatures have tried to address. So I will turn it back over to Senators Dibble and Representative Klevorn.
Before we do that, I just want to remind people that this is being recorded and the PowerPoint will be made available on our website. So if we would speeded through that a little quickly, you can always go back and get the clarity you need. With that, I would ask Senator Dibble or Representative Klevorn to make any comments that they wish. And in the meantime, those of you wanting to ask questions, please do so in the chat room. Thank you. Go ahead.
Well, I'm happy to defer to Representative Klevorn. Why don't you go ahead, Ginny?
Thank you, Senator. Normally the House would defer to the Senate, just in social polite company, not on the floor. Thank you very much for that wonderful overview, Suzy. I think you've captured the bill very well and the concerns that the Senator and I have been hearing from our communities, our neighbors, and residents across the state. Really, the purpose of this legislation is to make sure that there is a certainty between our families and the clients of any assisted living or housing with services, that when we have a family member who is going into care, that they're actually receiving the care and the protections that they need. I think it's a basic common good that we're looking for here, and I'm committed to making sure that we do the very best we can by our seniors and our families. When I think about our seniors and all of the many gifts that they have shared with us as residents of the state of Minnesota, the least that we can do is make sure that they have protection during their twilight years. We all are aging, we are all children of parents and grandparents, and it's our obligation to make sure that every Minnesotan is safe and has a dignified place to live. And so with that, I will pass it on to Senator Dibble.
Thank you, Representative, and thank you everyone at Elder Voices Family Advocates for all of your work and for today's presentation and for inviting us to be a part of it. And thank you, Suzy, in particular, for the outline of the legislation. I just wanted to mention a couple of things briefly, and but more importantly, I want to get to the conversation and the questions, because I think that'll be more interesting to everyone attending, and of course more rich and more robust. This legislation, I think it was mentioned briefly, somewhat comes about in the context of seeking a delay in the implementation of the larger bill that was passed a couple of years ago, in requiring that assisted living facilities and other unlicensed care settings at the community level become licensed. Understandably, the Department of Health is seeking a delay in the process, or slowing down the process somewhat. That's known as writing rules, the rule writing that would lead to full implementation of licensure of these settings. And the reason, of course, being that the pandemic has completely swamped and overwhelmed an otherwise fairly small agency. And so that's perfectly rational and logical. However, as has been articulated well by Kris and Suzy, and many of you in the form of your telling your stories to Elder Voices and your elected officials, you know, what's going on with the pandemic actually highlights and really helps put a focus on the reason we've had to pass a bill in the first place. And, you know, I would venture that we would be seeking some of this legislation completely outside of the context of a conversation around delay in licensure. There are things that people need to be well cared for, to be safe where they live, regardless of whether or not we're on a path or trajectory towards licensure. And so this is an important conversation to have regardless. I also just wanted to say quickly that I want to recognize the Department of Health for the efforts they have gone to address, particularly around COVID-19, some of the infections issues. Of course, the number of infections in long-term care settings, whether those are nursing homes or assisted living or other kinds of care settings, is way too high, and it's tragic in every instance. But to avoid wholesale panic, it's important to know that I think I'm not sure of the exact statistics, but fully half or more of those settings have no infection, so that's good news. And the issues around isolation, there are efforts to address that. Window visits and outdoor visits were kind of the start to that, and under fairly stringent protocols, allowing folks and designated caregivers to go inside facilities. But as Suzy pointed out, there's still a lot more that could be done around helping every facility understand the guidance and follow it closely, making sure that all facilities are addressing isolation issues. A lot of this guidance is voluntary, so that's also important. And then when we get into the conversation, I think both Representative Klevorn and I want to talk about what's needed. And the short version of that, and we can get into it in more, and I have some resources that I'll throw into the chat room or maybe throw up on the screen if screen share is available. And that is, we need people to engage with their elected officials as we move towards potential special sessions. Additional special sessions might be one coming up in a couple of weeks in September. Or, if we don't have special sessions, any more special sessions, certainly we need these issues addressed in the next regular session. And so you need to know who your elected representative is and how to best engage with them around the priorities and values and ideas that you have to make sure that our seniors are well cared for. So thank you.
That just generated a question for me, and I'll give time for others to ask their questions. What's the best way of reaching out to you? Do you want a phone call? Do you want an email? What do you advise?
Ginny, why don't you start off, and I'm going to do a little technological magic here because I did find a good resource to share with people, but I have to do a little clicking around on my computer. So go
for it.
So I would say always in the House, especially because we are a part-time legislature and because we are working in COVID, the best way to reach us right now is through our email. And anyone can find out who their representative is by either going to the Minnesota Revisor's website to say who represents me, or even to the Secretary of State's website, who represents me. And you can quickly get that information. And I'm hoping Senator Dibble will share that with us. But email is the easiest and fastest way to reach us.
As long as you have the floor, Representative Klevorn. Sorry, I'm not going to let you go quite yet. Regarding the subject of the delay for the assisted living licensure, as you know, Elder Voice is very concerned about that issue because we just don't want that the care to deteriorate as it has for another full year. What are your colleagues and others thinking about that issue? And yourself, obviously.
I'll speak for myself first. I'm not really a fan of delay. The compromise bill that was brought forward that had the protections in it that we voted on in 2019 was the work of many partners. And we have had a substantial amount of time to start putting those pieces into place. So for me, I would like to see those protections and rights go into effect at the date that all parties agreed to first. So that's me as Representative Klevorn. In the House, and speaking with my colleagues, when we first introduced the bill, there were 2 of us who signed on to the bill. The second time I introduced the bill, we had 17 legislators. as the legislators are starting to understand more and more the fact that these protections are so necessary, especially in the time of COVID, there's not a huge appetite for delay. Certainly, things can change, as we know every day the situation regarding COVID is changing. But with the desire for delay, if that were to happen, it could only happen if we really got these protections into place. So I would be a strong advocate for saying, first, no delay. And then if for some reason delay was deemed essential, then it could only be with these necessary protections in place. The general population doesn't understand that assisted living isn't licensed at this point in time. They're always surprised to hear that, and to find that Minnesota is one of the states that was so slow in bringing licensure along. And our families want certainty and they want safety of knowing that their loved one is cared for and that the services they're paying for are actually being provided. And the thought that mom or dad could be discharged to a homeless shelter is something that is incomprehensible to most. And so these protections are definitely needed, and that's what I would be pushing for in the House.
Thank you. Senator Dibble, I see you found your document. Thank you.
Yeah, so this is just a, and I put the link to this in the chat room, and this is just a quick thumbnail sketch of citizen lobbying from a League of Women Voters chapter in another state. So ignore these phone numbers and the like. But it's a good, just a good overview of just doing basic effective communication with your legislator. I won't go through it all, other than to some of this, of course, assumes no pandemic is going on. So the in-person visit, of course, is really not an option. Telephone, we do have folks, our staff is answering our phones. Sometimes we answer our own, so that might be effective. But probably the best thing is communicating with us by email and by handwritten, the old-fashioned snail mail. It is important that you're communicating with your own legislator and not other legislators. It just doesn't really do you any good to be communicating with folks who aren't representing the area in which you live. And so to find that out, I also put in the chat room how to find your legislator, and I can pull that up. Let's see if I can actually change my screen here. I'll do the stop share, share screen, and that's, let's see.
Scott, while you're looking for that, if I could just say, anyone who's wanting to reach their Minnesota House of Representatives, you start with rep.firstname.lastname@house.mn. Very simple.
It's not quite as simple. There we are. It's not, so here's a where you can just plug in here. I'll plug in my own address, and you can see how easy this is. Some of us in the legislature use what's called a web form to avoid getting a whole bunch of emails from folks outside of our district. And so not all of us have that same email convention. Actually, not everyone in the House has that exact same email convention either. So you can go to our website and see, it says use mail form. And then you can fill out this form and send me an email that way. So that's how to find your own legislator. But remember, we're in an election year as well. And so I just wanted to mention that there are folks running for office who want to represent you. And so it's very easy. I put also in the chat room the Secretary of State website's candidate filing website. And so here is that. And so once you figure out your district number, you can go to state Senate offices and see everyone who's filed for office in like Senate District 2, for example, et cetera. And oftentimes they have their contact information. So here, I'll just go down to mine again. So that's me. And I have my campaign website. And that's a way to get in touch with folks who are who are maybe not yet incumbents and who you want to engage on this question. I'm trying to figure out how to get out of that now.
And also too, I would suggest that you look at the members who serve on the long-term care committees, both in the House and in the Senate. And the people who serve on those committees are most often willing to listen to people who have concerns and issues that are the committee's work.
And then finally, I'll just say the most important information for us from our constituents is your story. What is the lived experience and how does it relate to this package of policies that are under consideration? Context is everything for us. Facts and statistics and all of that, also very important research and evidence, very, very important, but we understand all of that information in the context of people's stories and what's happened in their lives. And that's what creates the resonance, that's what creates the urgency for action.
If I might ask our legislators, I'm getting questions and I have questions. Are we having another special session? Or, what'll happen in these special sessions? Do most of these issues that we're talking about, will they really get handled in the coming months, or do you think it's more likely next year?
Well, that's an excellent question to which we don't actually have the answer, but we can talk a little bit about the factors that are going into the decision about whether or not to have another special session, what would be a fourth special session in September. So the short version is that we're in the midst of a declared peacetime emergency as declared by the governor for the purpose of fashioning an effective response, mobilizing resources and putting in place in a more efficient way than is available through the legislative lawmaking process, the kinds of policies and procedures and aligning the kinds of services that need to be aligned in an efficient manner to respond to a dire crisis. I mean, it's thousands of people dying and thousands more getting very, very sick, and an economy that's suffering the consequences and the like. And in order for a peacetime emergency to continue, it has to be renewed every 30 days when the legislature is not in session, and the legislature has to be called into session, and the only person who can do that is the governor, and that's to give the legislature that's the balance of powers between the branches of government. So that's to give the legislature the opportunity to say no, there will be no more peacetime emergency. If the legislature doesn't take that action, then the extension of the peacetime emergency continues. And so that'll be up in about a week and a half or 2 weeks, and the governor will have that opportunity to call another session. However, people may have noticed this whole subject has become very, very contentious. And unfortunately, on a partisan basis, the Senate is in majority control from Republicans. And they have sought now several times to end the peacetime emergency. And they've now made some other actions contingent upon his ceasing the peacetime emergency, some other important things like confirming commissioners of his agencies. There's a link now that's been made between whether or not they're going to effectively fire the heads of his agencies that are members of his cabinet. And if they take that action, which they've already done, in one instance, that person actually has to leave their office, has to put everything in their box and leave by the end of business that day. I mean, it's a very consequential action that the Senate has available to take. Additionally, the passage of what we call the bonding bill, the investments that we make in capital infrastructure, has been linked to whether or not the governor is willing to relinquish his peacetime emergency and delegate all of that authority to the legislature itself. And other issues have been linked. And so it's an open question of whether or not the governor is going to continue to seek that same mechanism to affect the executive branch response in the face of the pandemic. And so I don't know the answer to the question, but those are the dynamics that are under consideration right now.
I would say from the House perspective, we in the House have always voted against suspension of the rules, which would allow this discussion to come before the floor as to whether we would take up a resolution to stop the peacetime order. And I think it's important to know that 49 of 50 states still have these peacetime orders in place. And they're very important because they allow the governor avenues of reallocating his resources so that in the executive branch, he can move resources around as necessary. And also it allows him to make necessary purchases for our state without having to go through the statutory requirements for purchasing. And it also allows him to mobilize resources as may be required by the pandemic. So it's really important that we are in this state of mind with COVID at this time, especially since we are a part-time legislature. And so we're not sitting at the Capitol at this time for him to have this opportunity to make these important decisions for our state. We have not yet heard in the House if we are anticipating a special session again. There are many articles floating around in the press that say that there are reasons why the governor should or should not call us back. Some of those Senator Dibble just stated. I'm like everyone else, we have our bill ready to go. It's already in the hopper, ready to be introduced the first day that we're back, whatever date that might be. So the advocacy continues, the work continues, and we will keep striving for these protections for our families.
Thank you, both of you. A couple of comments that have come in, and I just want to point out, one from Mary Jo George, AARP lobbyist, just points out that New Jersey has passed legislation that would require 90% of Medicaid payments to nursing homes go to the staff wages. And we know frontline staff are often underpaid and lack sick leave. This will be another issue we need to address to get real reform. And Mary Jo, we agree. The research is showing that underpaid staff affects the quality of care given. And that's an issue area that will have a lot of interest as well. Another comment here for the legislators, has MDH / the governor helped with the proposed efforts outlined in the PPT, and or what role can you ask them to play in the future to helping those improvements be passed?
Senator Dibble, do you want to go first?
What is PPT?
What do you want me to repeat that?
No, what is PPT?
PowerPoint.
Oh. Very quickly, the Department of Health and the governor's staff, as well as legislators and various representatives of both what we call the consumers, organizations like Elder Voice, Family Advocates, AARP, and others, and industry, those who represent the nursing homes and the other types of care facilities, have been engaged in conversations about some of these provisions and have been trying to negotiate, what's workable and some of the particularities, what's acceptable, what can be, what's not, where compromises might be available, who's going to pay for things like PPE and testing, where those resources might be available, who's responsible, who should pay, or where responsibility should be shared, et cetera. And also many may be aware that a number of guidance documents have been issued by the Department of Health around procedures and protocols, and for things like visitation, for infection control procedures and protocols in the facilities, et cetera, and other sorts of actions like that have been taken. And so there's a lot of conversation. One of our interests is seeing if we might be able to create a statutory underpinning for these guidance documents around infection control and visitation, et cetera, prioritizing where PPE is going to be deployed, et cetera. Part of the problem is a lot of this is voluntary. It's guidance, it's suggestions, and for example, with visitation and the like, this isolation issue is enormous. It has tremendously negative health consequences for seniors, and so we're looking for if we can put in place sufficient protocols to keep people safe from infection, also getting their designated caregivers, their family members, in to these facilities so that they can have not just human warmth and contact from people who love them and who they love, but also making sure that there are families inside with their eyes on their loved ones to see what's going on exactly with them in terms of the quality of their care. Does that answer the question?
Well, I will add just a little bit to that, Senator Dibble. One of the questions that Mary Jo started with was the New Jersey rule about 90% of those Medicaid payments going strictly to the workers who do the work. I do think that this is something that we need to have a really closer look on. The work is physically hard and the pay is incredibly low. And the question is, why is that? That's the question that always comes to my mind. When you have a family member who may be paying $6,000 or $8,000 for assisted living or memory care, where are those resources actually going? I would like to know a little bit more from our care provider industry, exactly what is the relationship between the landlord and what is the relationship between the service provider, and where are the funds being transferred between the two, and how does that look in our state to make sure that the resources are actually going to the care that our families need. And especially when public dollars are involved, I, as a legislator, would like to see a little more transparency in that. What is the cost and where is the money going? I am a firm believer in always follow the money trail, and maybe we'll receive some of those answers. If there was a recent article in Harper's Magazine that talked about elder abuse and why it occurs and where the money flows. And that article has caused me to have a few more questions that I would like to have answered. And so we do need to find out where the resources are going and why are those wages kept so low. I know that I have voted for higher wages, and I'm certain that Senator Dibble has also voted for higher wages for our care attendants. So there is a space in there for us to have that really important discussion and to make sure that the staffing ratios are correct as well.
I'll just agree 1,000 times over. Pay for those in long-term care settings is embarrassingly low for such an important job, and it has a tremendous consequence. My sister is an LPN at a nursing home. So she's paid a little bit more than she was before she became an LPN just a couple of months ago, but not nearly. I don't think she's compensated nearly to the level of value that she brings to our state and our society and people's lives for those that she cares for. And so it is part and parcel of reform, but we also need to make sure that this is a conversation happening at the federal level. A few years ago, we dedicated a certain portion of our increased reimbursement rate to wages, and the feds came back and said, you put too much in that bucket, and we're not going to match that with matching federal dollars. And so you're going to have to, if you want to maintain those raises for all those employees in all those settings, you're going to have to make up the difference. You're going to have to pay us for what you did and make up the difference going forward. It was a huge fiscal dilemma for the state of Minnesota. So this is also something we need to engage our representatives in Congress around as well.
Thank you. We have another important question, and that is, how can we mandate better support for family members in regards to be better part of the care team of our loved ones? Thoughts from any of you?
Well, I think in the bill, we've taken the guidance for the essential family care provider and put it into session law. I believe that's there. Suzy, maybe you could correct me if I'm wrong, but it is important that we take some of the guidance that's been given, because as Senator Dibble said earlier, sorry about that. As he said, we have a collegial relationship.
Totally fine.
Yeah.
I don't stand on ceremony. I'm not wearing my white wig today or my robe. So.
Okay. As we talk about the importance and certainty and comfort that comes with family members being able to come in, what COVID has laid bare for all of us to see is the importance that our family care providers who are unpaid are providing for our family members in long-term care, whether it's making sure that their toenails are trimmed, or making sure that their hair is combed, or making sure that their food is enjoyable, or that they're even being fed. I mean, we've read some pretty awful stories about food that has come in, been put on the counter, and no one has come in to help that member, that community member, eat. So we are seeing the importance of those family members, and it has enabled some of our long-term care facilities to have fewer staff. And so for me, it's a win-win if we can put that into either session law or into statute, that our essential family members can come in and help with that service, especially those most intimate parts of care that we need on a regular basis. It's a win-win for both the care provider industry and for our families.
And
Go ahead. Go ahead. I was going to ask Elder Voices to respond to this question as well. But I'll just say quickly that I think we touched on it a little bit before. Some of the guidance allowing family members to come in is voluntary. We should make that not voluntary. And also, it's important to know that a number of the reforms that Elder Voice and AARP and others helped spearhead in passing the Elder Care and Vulnerable Adults Protection Act institute a number of really, really important changes that bring family members more meaningfully into the care continuum, especially in the form of communication and the rights of residents to designate who their caregivers are, and the rights for them to be informed, to be present, etc. But in the short term, absolutely, as Representative Klevorn said, we need people to be inside facilities, and it's risky. I mean, it's a huge risk when people are coming in from outside in the era of this pandemic. So we need really strong and stringent safeguards so that we're not putting residents and others at risk. But we need to acknowledge that families are absolutely a part of the care of seniors in long-term care settings.
And just to add to that, we get daily calls from family members who are desperate to get in to help there, because they've been in the past, a care provider, and they helped with a lot of the basic care that the facility didn't have to. But we're seeing that there are some really great long-term care providers who are doing a really good job of doing the best they can to get the families, a safe access to their loved ones. But there are others who are making zero attempt. And just yesterday, last night, I actually got a call from one family who the mother has lost 30 pounds in 1 month. And she's desperate to get the answers to what's going on and isn't finding that out. So those are the situations that are making it difficult for the good providers as well. But we're here to try to address the other issues as well. One person here has just pointed out the DFL Senior Caucus as a resource, and they've got chapters. And if there's interest there. I'm not plugging a party, I'm just pointing out to some of the comments made here. And then also another, take a look in the note from Elon Caspi, who is a gerontologist and one of the founding members of Elder Voice, points out another resource as well. Elon's been terrific. And then another question here, people who are still independent move into a place that advertises being independent and assisted living place. Now the independent person is subjected to the rules of assisted living people. Can those restrictions be changed? These places are licensed as assisted living places. That's an escalating problem.
Yeah. And I think too, I think it would be interesting for us as legislators to maybe start looking at some of the truth in advertising that happens. And as a freshman legislator, I want to be a little careful here because I've not delved into that issue as deeply as I plan to in this next session. But to know what families are being told. I've heard stories of children who've gone with their parents to look at an independent living facility, and then when the children ask to see the contract in advance, the contracts are not forwarded. So the children can't help their parents navigate that legal contract. And we certainly don't want people signing away any of their rights based on the fear that one day they will need entry to an assisted living space. So we want to make sure that all of the independent living complexes, congregate care complexes, are following the same type of rental laws that are available to other people, and so that we don't have any ageism or sexism in those contracts as they are brought forward, and that all of our citizens are protected. And maybe, Suzy, this is a place where you could explain what's there.
Yeah, I'll just jump in real quick and then let Senator Dibble. Part of the question is, and there was a follow-up question, wait a minute, I thought assisted living wasn't licensed, and that is true. I think what the comment is referring to is that the regulations, the guidelines, the quote unquote rules that the person in the independent living apartment is being subjected to are the same as the person in the assisted living apartment. Because in our campus models, we may have apartment A as an independent apartment, apartment B as a person who is receiving assisted living services, and so in effect is an assisted living client, if you will. And so they're mixed in some of our campus models. Sometimes they're a separate wing within a building, but sometimes they're door to door, next door to each other. And so, as you can imagine, in order to keep, for a provider to keep who's servicing apartment B safe, they are then covering apartment A as well with some of those guidelines and rules. And this is part of what we talked about in the PowerPoint initially, is the continued field feedback of those who specifically went into independent. And they might have family members who were intending to come in and provide low levels of services, medication setup, things of that nature, who aren't able to come in. And so they are without their care plan for months now. And that's part of the essential caregiver package. The question is, can we fix that? That is a very difficult thing to do. In the legislation, it does address it, asking those contracts for independent living to be honored. But when they are so closely living with other persons receiving services, I honestly have had the unfortunate situation to say to certain individuals, you, in this time frame, if you have the choice going in, you're in a separate independent living apartment, you are likely better off, if that was your idea, is to bring in your family caregiver scenarios, to be not in a campus model, but in a separate independent 55 plus or some type of scenario. And that's really difficult to say because we know that that's not the intention of many. But the reality is some of our separate independent apartment buildings are not having those same restrictions for visitation. So
I did get a question privately sent to me regarding blanket legal immunity for long-term care during COVID. And, you know, obviously that's something that Elder Voice has a tremendous concern about, and we would be opposing that. Any of our speakers want to speak to that?
So this has come up in Minnesota. The industry has put that on their list of things they would like. In fact, I've introduced a bill seeking immunity from liability during COVID, and a number of other states have actually granted these kinds of immunity protections. So that's to be free, of course, from lawsuits under certain circumstances. You know, should the worst happen. And there's been a push at the federal level as well to exempt nursing homes as well as some other kinds of facilities from legal protections, lawsuits and the like, you know, for their failures to protect people from becoming infected. It's a terrible idea, and I'm opposed to it. It's terrible for the obvious reasons that it simply incents bad behavior and irresponsible behavior, and holds institutions harmless for their failure to protect people that they're tasked with protecting. It's actually unconscionable, and I'm surprised that they have the nerve to even ask for something like that, frankly.
Representative Klevorn?
That would be a solid no vote for me. I'm right with Senator Dibble. You know, there's an old saying that when my paycheck depends on X, you're going to get X. So if there's no incentive for people, I mean, I should back up that statement just a little bit. We do have many really good care providers who do the right thing. And I don't want to throw them under the bus, nor do I want to paint everybody with a broad brush. However, it's very difficult for our families to know who are the good actors and who are the poor actors. And no family should discover that after neglect or abuse, right? So to provide everyone with immunity for poor conduct, I think that's just a bad incentive, as the senator said, and it would be something I would not support.
So if I could add to that, this is simply using the COVID and the pandemic crisis as a pretext and a cover for gaining these sorts of liability protections. In fact, this industry has been seeking these kinds of protections from liability for their failures previous to the onset of the pandemic. So it's a kind of a warning to all that the context is presented as the pandemic, and that's really a pretext. And this effort and this push has been around for a number of years by a very, very powerful and very wealthy industry, the long-term care nursing home industry. And now they're really pushing hard in the context of this particular set of challenges that our country is facing.
And I think it's important for people to understand that some of the real estate that is operated as assisted living and independent living, they're actually owned by large hedge funds. I don't know if that's true in Minnesota, but it's true in other states. And so to have this immunity for just financial gain of the landlords, I can't see it. Or the care providers either.
Well, we're past our 2 o'clock hour, and I think we better put a wrap on this, but I want to thank Senator Dibble, Representative Klevorn, and Suzy Scheller. You all work like champions on this issue, and we very much appreciate that. And I very much appreciate all of those who have come to participate and learn more about this. Feel free to reach out to me, Kris Sundberg, at Elder Voice Family Advocates. Go to our website. We have additional information there as well. And certainly your legislators are anxious to hear from you, as well as the candidates running for office. So with that, I will say goodbye. Thank you very much, and we'll see you soon. Bye-bye.